Good afternoon and welcome to our first session for the day, which I'll call session 4. So we are going to discuss one question from constitutional law as a follow-up to what we did yesterday. Later in the day, when time and availability permitting, we will have other sessions, but I'll give you a signal on the platform so that uh, you are able to join if you want. And at this stage, let me be clear because we have done the learning already in LLB. I don't intend to give like the substantive lectures, but if for a particular need, uh, some of you would like a formal lecture on something that you don't have clarity or I don't have a previously recorded lecture. If you uh, let me know, I would give a formal lecture in that respect. Otherwise, you will just be doing it in a tutorial fashion as I've been doing since we started. So let us take note of that. So, so the question we are looking at is this. As I said, it's going to be like a very brief session. I think some people are still in the waiting room. Let me disable the waiting room. Just a minute, just trying to disable the waiting room so that they can come direct. Yeah, it's been disabled already. Good. So the question is this. Into form as the Attorney General, and as I said, this is a hypothetical, just a made up. So I just observe that a written constitution embodies the will of a people and must be interpreted as a living organism capable of growth and development. Okay. So let's assume that you've been asked to write a memorandum to Constitution Review Commission recommending 10 provisions of the 1992 Constitution that should be amended. And the question also says that justify each recommendation and explain the appropriate constitutional procedure for amending each provision. Support your answer with relevant legal authority. So this is the question. And before we proceed to attempt ideas as to how to deal with such a question, I must say that when you are preparing for any examination, especially the examination of the type that you are going to sit, the law school entrance examination, it is prudent or wise to be aware of also the seasons and the times in which we are. It is no secret that we have constitutional reform debate ongoing, and it has even been elevated to a high stage of having a committee, Professor Prempeh-led committee, trying to collate views, submissions regarding what should be added to the Constitution or what should be taken out of the Constitution or what should be modified in the Constitution. So when you are preparing for a law exams and such a national discourse is going on, you cannot ignore it and pretend that it cannot feature in your examination. Nobody says that will feature, but it is just wise that once we are dealing with constitutional law, we must be interested in arming ourselves with some of the provisions which we think are good candidates for reform. So let us, that is a justification for making up this question, okay? So the memorandum to the Constitution Review Commission or the Constitution Review Committee or whatever body you've been asked to write your recommendations to, a good answer will have to begin with an introduction, okay? An introduction, as I said in our previous sessions, that you don't have to ruffle and you don't have to engage in irrelevance and redundancies. Go straight to the point. But lest I forget, we have to actually do what we do all the time. We have to pray. So just a minute. Okay, so as we are told, if you forget and then you go back to it, you haven't committed any crime. So we pray. Heavenly Father, we thank you for the gift of knowledge and the opportunity to prepare for this important journey of writing Ghana School of Law Entrance Examination. Grant us clarity of mind, diligence in study, and humility to learn. Bless our discussions today, that they may sharpen our understanding and guide us toward wisdom. We entrust our efforts into your hands, knowing that success comes from you. Amen. Good. So, having introduced, let us continue with what we're doing. So I said that we have a hypothetical question which we are discussing, and the hypothetical question is essentially requiring us to make some recommendations for amendments of our constitution. And I said that a good answer will have to begin with an introduction, and then the introduction must be straightforward to the point. You tell us exactly what the question requires us to do, situate the question. You were given a quotation, right, to forward the Attorney General. The Constitution is a living organism. And yesterday we talked about that, meaning that the Constitution is not supposed to be a static document. It's supposed to be responsive to changing circumstances in society. And that is why from time to time, it will be necessary to rework the Constitution to reflect the needs of society. And that provides an appropriate backdrop or background for the invitation which have been extended to you to make recommendations for reform or amendments of our Constitution, as it were. So having done that, you have to now get ready with 10 provisions, okay? And now we even suggest that to be on the safer side, if you can even prepare with 15, okay? So that if you go to the exams and, for example, they have asked you to provide 5 recommendations, then you're already armed. So it's better to over-prepare than to under-prepare. I'm teaching. Okay, yeah, so I will recommend that you work towards 15 instead of 10. Now, for each recommendation, or for each provision which you are penciling as a candidate, you need to state the provision, give the reason for the amendment, okay? Whether you want to be amended or even you want it to be repealed at all, you have to give a reason. What is wrong with what is the problem, okay? What is the problem with that particular provision? And again, if there's a problem, then you might have identified a solution, okay? A minute, let me switch on my condition. No. Right, thank you. Yes. So if you have identified a provision as a candidate for amendment, right, in a constitutional review, you must tell us why you think that that provision is problematic. Now, having diagnosed or pointed out what has been the problem or the challenge with that provision, you must specify or you must tell us what you think will be the solution. So the solution is what is going to actually be the outcome of your recommendation, isn't it? And then let us know what amendment procedure is it entrenched or not entrenched? And yesterday we discussed that, so we will not belabor that point. Is it entrenched or not entrenched? Then you must also cite relevant cases or authorities, as it were. Okay? If there's a relevant case law, or maybe if there's some academic commentary or some policy document somewhere which is relevant to what you are talking about, you have to allude to it to buttress your recommendation. And finally, you must provide a conclusion, the reminder that constitutional reform strengthens sovereignty and democratic governance. As we are told in our constitution, that the authority or governmental powers and authority emanate from the sovereign will of the people of Ghana. So the constitution is an exercise of our right to self-determination. In other words, we are making determination as to how we want our affairs to be governed. So if at a particular point in time, we are convinced by principle of democratic legitimacy, by popular consensus of the majority, that certain things are not fit for purpose, and we need to recalibrate, we need to retweak, we need to modify, we need to do that. And that is the spirit of the dictum in 2-4 verse Attorney General, which are the giving judicial blessing or imprimantur in litany of cases, which you are very much aware. Good. So what we are doing next is to just give what you call representative or indicative recommendation. That what I'm saying, it does not mean that these are the only provisions which you can actually amend. No, there are a lot of them, right? There are a lot of them out there which you can actually amend. So what we are providing is just a sample. So and let me say that if you wanted to get more, assuming you have not been following the ongoing debates yet, you wanted to get maybe like a ready-made response, you can just the 2010 CRC report is there. Of course, some of the recommendations are a bit outmoded, but a good number of them are so useful. So if you look at the executive summary of that report, you get a lot of them there. Or you can also follow the ongoing national discourse and the work of the Professor Prempeh-led Constitutional Review Committee to know what is going on. So if you look at the Article 78, now Article 78 clause 1, for example, Article 78 clause 1, as you remember, requires that majority of the ministers ministers of state should actually come from parliament. That is what Article 78(1) actually instructs, that the president must appoint majority of the ministers with prior approval of parliament from parliament. Now, that has been a challenge in a number of ways. First, from constitutional theory point of view, when it comes to separation of powers, such a situation actually blurs the doctrine of separation of powers as reflected in our constitution. In what ways? Parliament is supposed to exercise oversight, okay, over other arms of government, including the executive. So if it happens that majority of ministers are going to come from parliament, then we have a problem. We have a problem in the sense that you end up having a situation of a player and what? And a referee, isn't it? So when it comes to the parliamentary oversight over executive, the executive essentially is also the parliament, and that may not enhance parliamentary oversight very well. I mean, aware of the fact that regardless of how strict you are about principles, we are still human beings, okay? So the MPs who sit in the chamber of parliament, they are friends, they are colleagues, and all that. So if it happens that your friend MP is a minister and ministry is under your scrutiny, it is expected that the strictness may probably not be as we would like to have it, and that will weaken parliamentary oversight. So that has been the problem. And quite apart from that, it also undermines the work of parliament, because if you have, especially if you have like a hung parliament, okay? We had a hung parliament from our previous parliament, and that is 2020 to 2024. We had a situation where the government of the day did not have parliamentary majority and had almost nearly the same number as the opposition. But the constitution says that you should appoint majority of ministers from what? From parliament. And our recent constitutional political history, going back to 1993 up to date, will actually validate the observation that almost all the time, since the coming to force of the fourth Republican Constitution, we get a government appointing the ministers from its party. So what we call the winner takes all, as you remember. So certainly, if you have like a hung parliament, then it's going to affect availability of MPs in parliament for parliamentary business. And that is one of the reasons why some people have identified Article 78 clause 1 as problematic, and for that matter, a candidate for reform. Again, so it is recommended that that provision should be amended to require ministers to be appointed from outside parliament, or even if not, to require ministers to be appointed from parliament. Another solution may be to amend it so that you don't have to appoint majority of ministers from parliament. Some of the ministers will come from parliament, but there should be no constitutional stipulation that majority of them should come from parliament. Now, the questions require you to indicate, is it entrenched? Yes, certainly, as we saw yesterday, all the provisions relating to the executive are entrenched provisions. And you need to go through elaborate procedure, including referendum, as under Article 290. And of course, you look at there are a lot of cases. We can cite a lot of cases. Even J.H. Mensah versus Attorney General, the problem that we are talking about also came up. Particularly so, the Constitution says that you need like the prior approval of what? Prior approval of the Parliament. So if you have like a government in power which has also been re-elected, and then the president decided to retain most of the ministers, as they go through the parliamentary approval in terms of straight vetting as they were earlier vetted. That was the situation in the J.H. Mensah versus Attorney General. And of course, there are other examples that we can see. The recent case of the Speaker of Parliament. Another candidate is Article 71. As for Article 71, on the salaries or emoluments of the certain public office holders, I think that almost all of us, even if we just wake up from sleep, we'll be able to speak to it in terms of its being a candidate for reform. So the problem with Article 71, there are various layers. Maybe speaking from the point of view of, okay, I think somebody's hand is up. Let me allow him. But mind you, let me give all of you one. When you are speaking, this is being recorded and it to be uploaded on the Ghana Law TV channel. So be mindful of that. Okay, all right. So let me release you. Okay, so Biniba or somebody, what you can speak. Yeah.
Thank you so much, Doc. Please, it's in relation with Article 78.
Okay.
I wanted to know if, per the reasons of its amendment, if you could add that there should be a cap on the number of ministers the president should appoint.
Okay.
If you can add it to it, so that it should include that.
Yeah, I think that is also another problem. So, of course, the issues we are talking about are not exhaustive. So, you are quite right. That is another challenge which has also come up since operationalization of Article 78 over the last 3 decades. That we have seen variation in governmental practices or style. You get some government who would appoint so many ministers. And now, the current government, we monitored his campaign promise that he's going to have like a reduced number of ministers. So far, I think that we agreed that they've not breached that promise. We pray and hope that they remain true to that. But we shouldn't bank our hope on such aspiration. If we think that it is important to cap ministers, it should be done constitutionally rather than leaving it to the goodwill and pleasures of the political parties or government of the day. Yeah, so you are right. So that is another reasonable candidate that, yes, we have operated various governments more than 5, 6, 8 different governments over the past 30 years. Now we have a reasonable idea of how many ministers we need to actually run the affairs of governance. So should we say that we have 50 ministers, should it be 40 or whatever. If you want to make that as part of the issues for reform under Article 78, I mean, you're very much encouraged to do that. But at the end of the day, what is important is for you to articulate your argument clearly. Okay? Good, thank you. So, Article 71, we know the issues. No, Article 71, certain public office holders have been provided, and in terms of their emolument, their salaries, end of service, benefits, and so on, they have been charged on the consolidated fund, as it were, and they are determined in a very unique way, not in the usual way of determination of salaries and pensions, and that have given rise to a lot of public resentment and concern, but we have to always, diverge or like, disconnect or divorce, emotions from reason. So we need to find out what is the problem. What is the problem as far as the issues that we are talking about are concerned? Is it a case that we have too many, office holders under that, salaries and other emoluments regime, so that you put so much burden on the state first? Or is it the case that the so-called ex gratia is not a good idea? So when people come to serve as MPs and they are going 4 years, they should not be given as like a whole pension. What do we call like the probably like the ex gratia or something like that? What is it? So what is the problem? Does it create inequality? Does it mean that those who are given the particular treatment, they are sort of giving preferential treatment over and above other public office holders? So is it some form of like a discrimination, or as it were? So those are some of the things that we need to talk about. But also don't forget that if you take the judiciary, for example, we have what they call the independence of the judiciary. And related to that is also financial independence and emoluments of judges and magistrates and judicial office holders. So how does the problems we've identified with Article 71 impinge on all those areas? Or should we, what the problem has to be that when the government is about to go, the government will set up like a committee, as the Constitution has directed, to make recommendations for what the salary level should be. Because for the 4 years preceding that, they will not have any salary increment. And then when the determinations are made, then they are paid arrears of the increment which they should have been given for each year, as other employees are given annual increment. So the concern for some people is that because the government, is a beneficiary of the recommendation, the committee that will set up to make the recommendation may probably not be objective enough or whatever. So some recommend that establish an independent salaries and emolument commission. Okay, maybe either you allow the Fair Wages Commission, or you have like a dedicated permanent independent salary emolument commission, which will work out the salary levels and other emoluments for those under Article 71 regime. As we know, it is part of the executive. So it's an entrenched part of there's chapter 8 or whatever on the executive. So it's an entrenched provision. So you need to go through the procedure for amending entrenched provision. And of course, you know the case of Asalia versus Attorney General, where the court reiterated the fact that the sovereignty of the people, as reflected in the Constitution, must always provide guidance regarding how matters are done. There are a lot of so many other authorities regarding that. Now, when it comes to another candidate is Article 243, appointment of MMDCs. That is a metropolitan, municipal, and district chief executives officers. Those who are in charge of the Metropolitan Assembly, Municipal Assembly, and the district assemblies. Now, if you look at Article 243, you will notice that these MMDCs are supposed to be appointed by the president. Is a president who appoint them, but with a prior approval of not less than 2/3 majority of members of the assembly present and voting at the meeting. So that is a constitutional position. But it has been pointed out by some thinkers that such arrangement actually weakens local democracy or democracy at the grassroots. In the sense that, as we know, we may even have a situation, whether we like it or not, the blue state and the red state, which we have in the US, like the US, some states are traditionally Republicans, some states are traditional Democrats. Has caught up with us in Ghana, whether we like it or not. And we shouldn't be, for me, so long as we respect the fact that there are divergence of opinions, right, regarding how things should be done in our country, having diversity or pluralism in terms of political viewpoint or affiliation, there's nothing wrong. The most important thing is that there's much mutual respect and accommodation. So there's nothing wrong for certain areas to be traditionally, let's say, NDC areas, and certain areas to be traditionally NPP areas, and certain areas to be traditionally, what's the other, some of the strong third parties, probably CPP areas. There should be nothing wrong with that. But the most important thing is that there should be tolerance and accommodation and mutual respect. So if that is the case, and I must say that if you look at the ground, we see it, at least the past 30 years, we can say that certain areas are traditionally NDC, are traditionally NPP. So if you have that situation, okay, and you have a district assembly elections, which says that it's supposed to be non-partisan, okay? It's supposed to be non-partisan, and people should actually be elected not on basis of any particular party. But the reality is that these political parties, they put up proxy candidates. So you are going to get, let's say that the opposition party having a lot of assemblymen or women in a particular district assembly. And then where that is the case, then you are going to run into a problem. So some have suggested that in order to avoid such a situation, why not allow the local people to select their own MCs or DCs, as it were. So there's the recommendation for popular election of MMDCs. And I think if you look at the Article 240, Article 240, in terms of list of the entrenched and the non-entrenched provisions under Article 290. If you go to Article 290, you will notice that Article 240 has been listed under Article 290 Clause 1O as being an entrenched provision. And being an entrenched provision means that you need to go to referendum before you will be able to amend it. So let us take note of that. Another candidate for reform is Article 64, Clause 2. Article 64, Clause 2, relating to presidential elections, as we know. So if you look at the Constitution, Article 64, Clause 2 says that a declaration by the Supreme Court that the election of president is not valid shall be without prejudice to anything done by the president. So let's start from the clause 1. The validity of the election of the president may be challenged only by a citizen of Ghana who may present a petition for the purpose to the Supreme Court within 21 days after the declaration of the results of the election, in respect of which the petition is presented. Well, some people, of course, we can disagree on this. So these issues and recommendations that we are actually pinpointing should not be taken as a gospel truth. My purpose in this session is just to train your minds to know how to go about that type of question. So all that I am seeking to help you to develop the ability to recognize some provisions of the 1992 Constitution, which, in your considered view, ought to be amended. And you need to let us know what the problem is, what the problem has been, as far as that particular provision is concerned, and in what way should it be amended so as to cure the problem. So that is the skill or the competency I am seeking to inculcate in you by this session. It doesn't mean that the particular provisions that I am flagging are supposed to be taken as exhaustive candidates or as the gospel truth. No. So as we look at Article 64, we are told that after the president has been elected or declared, the results have been declared. If you want to challenge it, you have 21 days to do that. So there's a school of thought who says that we can have presidential election in which the problems are so complex that 21 days may probably not be enough. But of course, you agree that building upon the aftermath of the first presidential election petition in 2012, Akufo-Addo against John Mahama, a lot of lessons have been learned, and the Electoral Commission, in my view, has put in place a number of mechanisms which overcome some, if not all, of the serious problems which actually affected that election. And for that matter, the argument that 21 days is not enough, probably in my view, may be untenable. And 21 days may be enough. Because if you look at even the fact that political parties are now able to deploy their agents all around the country, the polling stations, and they can even declare their own, they can ascertain their own results before the Electoral Commission officially come out. If there are problems that they have spotted, they will have documented it, and I think 21 days should be enough for you to file a challenge. But if you still agree with those who think that 21 days is short, then you may probably recommend that it should be extended up to 60 days. And then they put up the argument that if you look at Article 64, Clause 2, it says that where the Supreme Court has declared that a president was not properly elected, it will not affect validity of anything that he will have done before being declared as not properly elected. And for that matter, if there's an extension of the duration or the period within which you may file the challenge, it shouldn't really affect anything because of the saving clause and Article 64 clause 2 that the outcome of the presidential petition decision will be without prejudice to anything which the president has done and so on. Yeah, so you remember the case of Nanado against Mahama, the election petition of 2012, which highlighted some practical challenges. But at the same time, the countervailing argument will be that if you look at the is it 2016? No, not 2016, 2020, yeah, sorry. If you look at the 2020 petition, it was relatively simple. So that is probably a sign that there has been an improvement. Another candidate probably is the Article 11 of the Constitution. What's the problem with the Article 11 of the Constitution? If you look at Article 11 of the Constitution, it talks about sources of law in Ghana, right? And the sources of law, among other things, there's a mention of the customary law, right? There's a mention of customary law, and customary law has been defined in the Constitution in terms of Article 11, Clause 3, to be the rules of law which by custom are applicable to particular communities in Ghana. So keep that in mind. Now, the problem has to do with customary international law. As you know from your public international law, the coming together of sufficient state practice and then the opinious juries will crystallize or will culminate in formation of customary international law. So therefore, if you look at it, it has a lot of similarities with what we call our customary law, and even like the common law to as it were. But there's a problem as to whether that should not be included in our constitution. In terms of treaty, there's no doubt we are what we call a dualist country, right? A dualist country as opposed to monist country. Monism and dualism. Countries which subscribe to monism, they have what we call like a unified view of law, that there's one legal order, and if you like, the international law more or less being even superior, so that if a treaty is signed, it has automatic effect under municipal law, and there's no need for anything to be done in municipal law or the domestic law before it will have an effect. But then for the dualist country, you notice that they have what we call they don't have a unified view. They think that international legal order and the municipal legal order are two separate things, and obligations subscribed to under the international legal order in terms of treaties and conventions should not have automatic effect under municipal or domestic law unless there has been domestication or some incorporation of that. Like in Ghana, if you look at Article 75 of our constitution, Parliament may ratify by way of an act of parliament or by passing a resolution to that effect. Now, so there's no problem with that, but then the problem has to do with the customary international law aspect. A customary international law aspect. What should be the approach? And that is why some people are saying that let's amend our sources of law to include rules of customary international law. Of course, this is not like really a big deal, but then if you look at the CIBA case, which is about this, freedom of association. If you remember, the Council of Indigenous Business Association, what they call the CIBA, and there was a law which gave that association statutory recognition as a mouthpiece of indigenous business in Ghana. And there was a challenge of that it is wrong, that violates the freedom of association. And in fact, if we look at even international obligations, right? If we look at international obligations, which Ghana subscribed to the African Charter and so on, there has been a recognition of the freedom of association and the International Covenant on Civil and Political Rights and all that. So there was a challenge to that. And as you read the case, there was this issue as whether the PND's Law 312, which gave that recognition, actually violated this provision of the Constitution or not. Whether Parliament can actually create and impose a statutory body to represent a category of a private sector without their consent. And eventually, the Supreme Court took the view that that law was unconstitutional. Obviously, it violates the freedom of association. And freedom of association has also got its a reverse side or corollary. That is the right not to associate. If I have the freedom to join association, I also have the right not to join association. So you cannot force me to. And of course, those of you who remember the case of the Ward Brew against Ghana Bar Association, Attorney General, and all that. The Ghana Bar Association is like an association for lawyers, but strangely, those who made the constitution, they include the Ghana Bar Association in certain provisions as if it is a statutory organization. So we got some other lawyers, old senior bro, who got up and said that, okay, they don't want to associate with the Ghana Bar Association, that they want to have their own association because of freedom of association. So the CIBA case provides a context for that. Okay, so we will move on to look at the independence of the Electoral Commission. That is another candidate. So Article 46. If you look at Article 46, there's been a problem. And the problem has to be that following removal of Mrs. Charlotte Osei as the chairperson of the Electoral Commission and the deputies, it's become like a bit of like a political issue as to whether new government should be able to also engineer removal of who the members of the Electoral Commission are and get their own preferred people over there. So these are some of the problems. And of course, there's a constitutional law class. So I want you to think as lawyers, not as politicians, not as NPP and NDC followers. Okay, so think as people who want to become lawyers, not in terms of politics. Yeah, so if we look at Article 46 of the Constitution, for example, it talks about independence of the Electoral Commission. But then, if you look at the fact that in terms of Article 43, okay, so Article 43, for example, that is the composition of the commission, the chairman, two deputies and so on. And then we are told in terms of 43 clause 2 that the members of the commission shall be appointed by the president under Article 70. So the president appoints members of the Electoral Commission as part of the appointments that the president does under Article 70 on advice of the Council of State. Now, there's this concern that such a provision has a risk of undermining the independence of the Electoral Commission, as the members of the commission may want to do the bidding of the appointing government. So, to avoid that and also avoid the problem of saying that, okay, when NPP was in power, it removed Electoral Commission, which had been appointed at the time that the NDC was in power. So if NDC is in power now, we're also going to remove the Electoral Commission, which the NPP also appointed when it was in power. Then it become a bit like a cycle. So to guard against that, there has been some recommendation or some suggestion that let's solve this problem of potential partisanship in letting the Electoral Commission members be appointed solely by the president by either requiring parliamentary approval or some bipartisan council confirmation. Of course, we have the Council of State there, but there's this concern that that is not enough. So if we may probably bring parliamentary approval, but if we bring parliamentary approval too, probably similar to how Supreme Court judges are appointed, as whether that to solve that problem. Yeah, so that is the challenge. But it's, as I said, these things we are talking about are not cast in stone. These are ideas which are being floated, so that nobody is right and nobody is wrong. We are just thinking through. And then we have the Article 86, establishment of the NDC, NDPC, National Development Planning Commission. Now, this has been a very major source of concern. If you look at the 2010 Constitutional Review Commission report, it featured prominently. And almost all the time we are talking about it, that when we have changes in government, we tend to, abandon projects, and when political parties are seeking to come to power, they engage in a bit of what you call the populism, just trying to tell electorate things which will let them vote for them, rather than things which will actually drive the development of the country in a very coherent and consistent fashion. So we have National Development Planning Commission, which is supposed to do national development planning, national development plan, and so on. Now, the plans they do, practice indicate that they are often disregarded by successive governments, so that we don't make significant progress in our journey towards national development. But if we have like a national development blueprint, right, made by the National Development Planning Commission, which is actually made binding on all successive governments, so that if you are voted into power, you cannot ignore the current development plan, but you work with it until its period has expired and then the new one has been put in place. So to do that, there's this suggestion that let's make National Development Planning Commission plan binding on all government to ensure policy continuity. So therefore, if in our National Development Plan, we say that for the next 20 years, the major emphasis of our development in terms of physical development is going to be construction of roads, or railways or something like that, or school infrastructure or hospital or whatever. If you come into power, you are going to work within that framework. And thankfully, if we look at the National Development Planning Commission, no, I think it's an entrenched course because it's part of chapter 8. And if you look at it's part of chapter 8, so being part of chapter 8, automatically it is entrenched, so it will have to go through the procedure for the entrenched. Then what about private members bill? If you look at Article 108, we have restriction on private members bill. When we say a bill, you remember Article 106. Before we can have a legislation, it is introduced in Parliament as a bill, a proposed or draft law. Then to go through the processes for making a law. Now, if you look at the Article 108, when it comes to a bill which is going to bring into being a law that will have implication for financial matters on the state, the Article 108 requires that such a bill might be sponsored by the government of the day and is sponsored by the president, meaning that practically all legislation which will have some financial implication, either going to spend money from the public funds, consolidated fund, contingency funds, and so on, or going to impose taxes or levies on the citizenry, such a bill must be initiated and sponsored by the government or the president. So that effectively restricts private members' bill. So a private member bill can be taken where it doesn't have any financial implication on the state. And it limits parliamentary initiative in lawmaking, and it undermines checks on the executive because members of parliament might have observed something which they think that there's a need to introduce a certain law. Now, if the government of the day has not actually brought that law, such a law may never see the light of the day. So that is a problem. So there has been a call that such a provision should be amended so that it will not undermine ability of Parliament to also have initiative when it comes to law making. So if you look at Article 290, Clause 1J, you see that the chapter on legislature, the ones which are entrenched are Articles 93 and 106. Yeah, Article 93. But if you look at Article 106, for example, if you look at the provision itself, there is what you call a reference back to Article 108. So if you look at Article 106, Clause 2, that no bill other than such a bill as referred to in paragraph A of Article 108 of the Constitution shall be introduced in Parliament. Yeah, so there's that reference back, and for that matter, amending Article 108 may not be that simple on its own. It may have almost the same effect as an entrenched clause, as it were. Now, in terms of Parliament itself, the nature or the structure of our parliament. You know, typically we have what you call the bicameral parliament and unicameral parliament. That is, whether the parliament is just a one house or the parliament has more than one house, or upper house and the lower house, as the case may be. So we have unicameral legislature, meaning we have only one house, and there has been concern that there's that risk that it may be prone to executive dominance, particularly where you have the government of the day having comfortable majority in parliament. And I think that currently we have almost that situation. The government of the day practically has, I think, if I'm not mistaken, they have almost two-thirds comfortable majority. So that may undermine oversight of the legislature and lawmaking. But then, if you, for example, there's this law, this anti-LGBT law, for example, which was taken through. If we had, let's say that an upper chamber, they too have look at it from another level, so that we have a very comprehensive approach. But as it is now, bill are hurried through one chamber, and that's it. If it passes, it becomes law. So if you have like a unicameral system, sorry, if you have a bicameral system, that is having maybe like the upper house or senate, like as we have in probably like, let's say, Nigeria and the United States, for example, or in the UK. UK, they have the House of Commons and then the House of Lords. That will strengthen oversight over the executive and also enhance quality of lawmaking. So in the UK, for example, we go to the House of Lords, we have a very, senior, citizens, very experienced people, and of different backgrounds there. So when a law is being made and it goes there, they also bring a certain perspective to it before it will eventually be passed, as it were. But of course, that provision in Article 93, I think, is an entrenched provision. So we need the referendum. Then we also have the Article 187, Auditor General's powers. There has been a concern that despite the fact that the Auditor General has the power to disallow and also to surcharge, enforcement of the decisions of the Auditor General with respect to disallowance and surcharging remains weak. So there's a need to actually amend the law to strengthen the work of the Auditor General and make its decisions easy to enforce, as it were. So there's been a concern that the Auditor General should be given prosecutorial referral powers. So if you look at the Article 187, so that becomes like a candidate for review, as it were. So as it is, if the Auditor General, for example, should search out and is not done, the Auditor General doesn't have, if you like, the prosecutorial powers, as it were. Unlike, let's say, GRA, like the Ghana Revenue Authority, they have powers of prosecution. and they can come after you. So remember the case of the Occupy Ghana against the Attorney General. Okay, so these are some of the recommendations which may be made for purposes of dealing with a question like that. So I'll take some 2 or 3 intervention. I'll allow some 5 minutes before I close and go and do some other things. Maybe later on in the day we'll come back. Yes, so if there are any intervention, let me stop the recordings. Okay, let me pray and stop the recording. Ooh. The simple, gracious Lord, we are grateful for the time spent in learning together. May the lessons gained today remain in our hearts and minds. Strengthen us for the work ahead, calm our anxieties, and guide us to recall with accuracy what we have studied. May all our efforts bear fruit to your glory and to the service of justice and humanity. Amen.